Well, welcome to the show. I am your gracious host, Daniel, and today is another one of my favorite judges, Judge J Cedric Simpson. So, let's get started with this. I like Judge Simpson. Let's make this bigger. And let me mute my mic.
Does call the case of the People versus Stephen Grisbeck.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Grisbeck, who is approaching. Please state your name for the record, sir.
Stephen Grisbeck.
Thank you.
And Trace Claire on behalf of probation. Your Honor, Mr. Grisbeck is before the court for a review hearing. Mr. Grisbeck was ordered to complete the in-jail DD program prior to being released to continue supervision on probation. Mr. Grisbeck has failed to complete that DD program. In fact, he dropped out of class on July 16th. I checked with jail staff. They indicated that he dropped out of the class because he felt that he wasn't going to be able to be released from jail. So he's just not doing it. Given that he is not participating in the program and wanting to do things his way, probation is recommending, plus he has the other pending felony matters, Your Honor. Probation is recommending that probation be revoked, that Mr. Grisbeck be sentenced to 365 days in jail with credit for 175 days served, that he serve the balance, and that he be discharged from probation without.
Ms. Pate.
Thank you, Your Honor. Ms. Chelsea Fergiles from our office did meet with Mr. Grisbeck this morning and was able to discuss this with him as well as the recommendation. And it is my understanding, I will note, that Mr. Grisbeck's pending felonies do all have offense dates that seem to predate when he was sentenced to probation on this case. It's my understanding that he was sentenced to probation on May 5th of this year in this case.
And that is correct, Your Honor.
Yeah.
I just wanted them listed so the court's aware that he does have other pending felonies.
Yes, we do acknowledge it. Yes, those are pending, Your Honor. And it is my understanding, Ms. Vergiles advises that he is engaged in the MAP program at the jail. And that is correct that he has been in the jail for 173 days. It's my understanding that he has been engaged in classes while in the jail in Adebo. He has engaged in an anger management class. He is job seeking with a criminal record class and a criminal impulsivity class, as well as managing my emotions in my relationships class, with these completion dates of September 7th for three of the classes and September 8th for one. I do have a documentation of that Ms. Vergiles did provide with me. My client is respectfully requesting that the court to consider one of two things. He is asking if he could be allowed to restart his probation and restarts PATS in the jail. If not, he is asking if the court would consider a release to treatment at Sacred Heart. It is my understanding that in his pending felony cases, he does have a release to treatment at Sacred Heart. He does reside in Ann Arbor, and he was engaging in NA before he was in custody and would like to go back. Again, it's these criminal cases do predate his sentencing on probation. I do understand that he was not able to complete the DB class while in the jail. He did make an effort as an alternative while being in the PATS class. So that being said, Your Honor, we are asking if the court would consider letting him restart probation, or in the alternate, if the court is inclined to impose the jail sentence, if the court would consider a release to treatment to Sacred Heart.
Grisbeck, anything you want to say?
Not at this time, Your Honor.
Okay. I mean, part of the thing is that we were trying to get him at least through a certain portion of the class and then do something. And I don't, why I'm shaking my head is I don't know why he just stopped it. He just needed to get to a certain point. And for whatever reason, just couldn't do it. Sentence of the court, I'm going to revoke the defendant's probation. I'm going to sentence him to 365 days in jail. Credit for, you said 173, but I think
One,
Total altogether is 175.
175 days, so credit 175. Defendant is to serve the balance. I will discharge him from probation without improvement. All right. And Ms. Pate, if you want to submit a standardized order for release to treatment, I don't have a problem with it.
thank you very much, Your Honor. Yeah, that was my potential question. Thank you, Your Honor.
Court does call the case of People versus Angel Dietrich.
Call the law for the people.
And Assistant Public Defender Natalie Pate with and on behalf of Ms. Dietrich, who's present via Zoom. Ma'am, can you please unmute and state your name for the court?
Angel Dietrich.
Thank you.
Thank you, Your Honor. I ultimately have two requests. One, as to the pretrial, I'm respectfully requesting an adjournment. I have been able to discuss this case with my client, and she did over the weekend send me some documentation of some work she's doing that I am hopeful to review and discuss in tandem with the case with her. And as I do have a request briefly as to bond when appropriate, Your Honor.
I have, Ms. Dietrich, did you file some paperwork with the court this morning?
Yes.
And you probably haven't seen it.
So, Your Honor, I have not seen it. No, I was just made aware of that this morning. And I did advise my client to, in future, submit all documentation to me. And if appropriate, I would submit to the court on her behalf. But no, I have not seen exactly what it is, Your Honor.
Here's my problem with it, because it's unusual. I have therapy information here, which I would certainly, in most instances I would review, but then I don't hold on to it, and certainly I wouldn't put it in a public file in this fashion. I also have her receipts for the payment of her tether, but the difficulty, I got her actual receipts, so if that ever became an issue.
Yes, Your Honor.
And how did that go in? Did they note that in the file?
Did they note it in JIS?
Yeah.
I can take a look. There's nothing notated.
Okay. Here's what, Ms. Dietrich, because of the information that's in here, I don't think it should necessarily be in a court file.
Okay. I apologize.
Okay. No, you're okay. Don't worry. I understand you were trying to get information to the court. I get it. Do you mind if I return this to your attorney? Some of the stuff in here is also rather personal to you.
Yes.
Okay, yes, you don't have, you don't mind if I return it to Ms. Pate, do you?
No.
All right, thank you.
You're welcome.
All right, yeah.
Thank you very
Then-
much, Your Honor.
Can you mark that defendant filed those, but the court has returned them because of the nature of the information contained?
Yes.
Oh, okay, no, I just,
Thank you very much for that, Your Honor. I was not aware of everything that was filed. I was made aware this morning that there was a letter or two possibly dropped off, but yes.
Yeah.
So thank you very much, Your Honor. I will make sure this gets back to Ms. Dietrich. As to the pretrial, we were respectfully requesting an adjournment so I can review some paperwork that she did send to me via email over the weekend. So I would just be asking for possibly 2 to 3 weeks.
I'll adjourn it to October 20th, 2025, 9 a.m.
Thank you, Your Honor. And I do have a brief request as to bond when appropriate.
Yes.
So my client, which as Your Honor can see through the receipts, she is currently on a GPS tracking tether. To my understanding, she is compliant with that, and she does not currently reside with either complaining witness. She lives at an address that she did provide to me in Ann Arbor, that she stays with her mother. She is asking if the court would consider a removal of the GPS tether at this time. My understanding is she has no violations, and she does understand completely the no contact order and the no go-to order and will continue her compliance with that. But she's just asking largely for financial reasons that the tether be allowed to be removed.
Any response from the people?
Yes, Your Honor, at this time, the people would oppose any alterations of the current bond conditions, especially removal of the tether. There's been numerous domestic violence incidents in which the defendant put a belt around the victim's neck, began to tighten it. She's also accused of digging her nails in the minor victim So the victims are concerned due to her increasing acts of violence.
At this point, I'm not going to change any of her conditions to bond. When you say she now resides in Ann Arbor, in part of my thought process, I don't know how close that is to the address of this incident either, that she currently would reside. All right.
Understood, Your Honor.
Okay. Thank you.
Thank you, Your Honor. And thank you, Ms. Dietrich. You're all set for today and can log off the Zoom.
If a donation makes
Okay, thank you.
Court calls the case versus Travis Oliver.
Calvin Hall, open people.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Oliver, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Travis Oliver. Thank you, sir.
Probation, Your Honor. Mr. Oliver is scheduled before the court for a review hearing. Mr. Oliver has a balance of $865 left to the court was made on June 3rd of $50. Probation did set up a payment plan with Mr. Oliver, given that probation set him up with the domestic violence program, which does cost him weekly to attend that program. He is attending that program and is compliant. However, he does need to get caught up with payments. The payment plan that I set him up with was that he to pay $105 on a report today, then $95 per month. For the court's information, Mr. Oliver does have a new pending criminal case of alleged aggravated stalking with an alleged date of offense of June 8, 2025. Mr. Oliver was on bench warrant status with that. However, he did submit a bench warrant recall. He was allowed to walk in on that warrant today. It's my understanding that he did appear before the magistrate at 14A2 this morning on that warrant. However, JIS still indicates that it's in warrant status. I'm not sure which date is set for that. Mr. Oliver can update the court with that. I do know that Mr. Oliver did report having contact with the police with my office. I wasn't aware that any charges were filed from that until recent. Given that the case is pending, probation is asking that a violation of probation hearing be set for October 20th, 2025 at 1 p.m. for the alleged violation of the no contact order and it being a new criminal case, and that Mr. Oliver continue with all other terms as previously.
Thank you, Your Honor. I was able to discuss this with Mr. Oliver, and I did speak to both him and the attorney who handled his arraignment this morning. He was given a PR bond, Your Honor, in the new case, and he's set for PCC on the 25th in front of Your Honor on that new file.
On the 25th of this?
Yes, Your Honor, 25th.
Okay.
Other than that, my client did state to me, I was not able to verify online yet, that he paid $75 this morning or today. Other than that, Your Honor, we would be asking the court to adopt probation's recommendation.
Your Honor, I just see that $75 payment.
He did. Okay. So you want the difference before the 15th?
I would like that. Well, that's today, Your Honor. So I would like it by the end of the week so he can stay on track with the monies.
Got it. Before the end of the week, you said?
Yes. That would be
Okay. All right. All right. So here's what I'm going to order in the case. I've got all of the updates on that with his PCC date being 25th, and he's got a PR bond. The defendant was to pay $105 on it before today. However, and then $95 per month thereafter. It'd be $95 per month. He paid $75. He's to pay the additional $30 by September 19th, 2025.
File your tax.
You have the plea form, Your Honor?
I do.
Good day.
Hello, what's your name?
John Michael Funch.
All right, Mr. French, The plea form that I have indicates that the defendant will be pleading to an added count to a retail fraud in the third degree, the 93-day offense. On a successful plea, count one would be dismissed. That's the entire understanding of the.
That's correct, Your Honor.
May I have him sworn? Is that correct, Ms. Counsel?
Yeah, yes, sir. I'm just having trouble pulling up the plea form, but I'm sure that's right.
It's okay. Let's have him sworn.
I believe you.
Raise your right hand. Do you solemnly swear the affirmative testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I sure do.
State your name.
John Michael Bunch.
All right, sir, it is this court's understanding you're going to be pleading guilty to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased 3 times the value of the property taken. If that's greater than $500, that would be your maximum fine. You understand that?
Yes, I do.
All right. And understanding all of that, you still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on March 5th, 2025 at the location of 3300 Carpenter Road in Pittsfield Township, Washington County, State of Michigan? What did you do at the Home Depot that makes you think that you're guilty?
I had a tire to return and I kind of just returned it myself and there was a $20 difference, the price. And I just walked out with the tire.
You had a tire?
A tire for my wheelbarrow.
Oh, okay.
Was dumb.
And so
He purchased a tire at $39.
Right.
It didn't fit, so he brought it back into the store. And rather than waiting and doing the exchange with the customer service, he selected a $59 tire.
Is that all correct, sir?
It is, yes.
So, and then when you selected the new tire, you did that and you walked out without paying the
I
difference?
did, yes.
And you knew that's what you were doing at the time?
Yes, absolutely.
All right. You didn't have anybody's permission at Home Depot to do that, did you?
No, not at all.
And the item that you took out that was priced at the $59, that was an item that they had offered for sale?
They did, yes.
All right. Counsel, have I complied with the court rule? Well, sir, I do have to advise you that if between the time of the acceptance of this plea and your time of sentencing, that if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea. You understand that, sir?
Yes, won't happen again. Yes, I do.
And also, sir, any recommendation or evaluation by the court would no longer be entitled.
Yes.
The court would no longer be bound by. You understand that?
Yes, I do.
All right. Second, I'm checking. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
October 22nd at 12 noon.
October 22nd, 2025, 12 noon. Sir, looks like you have some other issues here.
No?
Well, I'm not.
Oh, sure.
Mr. Allen.
You don't have no warrants.
No, I don't. No. Yeah,
Right, I've got two warrants, and I've got a warrant, which this is an old case because it has a 97 case number on it. And it was transferred from our original case management system into the new one. I'm not sure why it appears the way that it does, but it's a civil case. But for whatever odd reason, has a 5,000 10% bond on the case. And they issued the bench warrant. It was a Samuel Hall Jr. versus John Prince. I don't know why that, when I'm looking at the case, there may have been, oh, I know why. All right. There was a subpoena, and I'm having to piece it together, but there was a subpoena that was issued. You didn't appear to court. Ultimately, at least my procedure was there was a show cause and then a bench warrant because you didn't appear.
Does it show he was served though, the subpoena?
I didn't know
that.
There was a point at which there was no service. I do see that on here, but then they filed a new subpoena. Discovery was filed, and at a later date, then the bench warrant was issued. So I have to assume that the bench warrant was issued. That was, although it's a 97 case, because I took over that docket, I'm listed actually as the judge of record in that case. But I would not be the one that would be handling it now. What I'm going to do in that case, because it's so old, on that one, I'm going to cancel the bench warrant. All right. And then I'll just indicate that they need to reset before Judge Barr, who's handling our civil docket. You have another civil case that's from 2020. And the plaintiff, and it's a civil matter, is a Susan Riesel. I don't know if you know that person versus you. In that case, again, it appears the same thing, except in 2023, a debtor's exam was scheduled before Judge Barr. And on April 18th of 2023, you failed to appear for that debtor's exam. The judge issued a warrant.
Was notice returned or?
I have no idea. I'm just looking at the file or at the printout. I would suspect that if notice were returned and Judge Barr knew about that, he would not have issued a warrant. But a bench warrant was issued on that. A bench warrant, for whatever odd reason, even though it was in April, was then issued October 10th of 2023, and it's gone through this year in February. The warrant was invalid.
We have case numbers because we don't have access.
I canceled the one,
Okay.
one case number, the one that there's a valid, let me just give it, one case number is 97-2C3143. That's the one that I canceled the warrant on. The other one is 2000, 4C0243. Both of them, it appears, come from small claims matters.
Your Honor, is
Um,
there an address in the 243? I'm trying to make sure you got notice of all this.
in the 243, there's the address of Parker Road, but I don't know when the warrant and everything came through, whether or not that was, no, I'm sorry, it's not Parker Road. It's Outer Drive. It's the same address that I have on this case.
So I'm asking the court to not take him into custody, but
It's a valid warrant. You're gonna have to address that before Judge Barr. That's his warrant that was issued on the civil case. It's a cash bond only warrant from his failure to appear for a debtor's exam.
But Your Honor, I'll be brief. As the court knows, we don't have access to JIS. Usually we'll run our clients' names through JIS and have the benefit of at least alerting our clients to warrants.
Right.
Without access to JIS, and I interviewed him in the court, I interviewed him in the interview room. He wasn't aware of any warrants. That's why I was asking about the addresses and whether he had properly been served the subpoenas or served with notice of those debtor hearings. And so because I don't have JIS, I can't help him.
I will straighten it out.
Well, I understand. And Mr. Brown, I appreciate what you're saying. I think it's what has transpired is just crazy regarding JAS. I don't agree with any of it at all. I think certainly to those that have asked, I've expressed that. This is the one danger that happens. People get locked up because you guys who do a fantastic job don't have the benefit of being able to get open access to the information that's contained in the case management file. It's an abomination. I do consider it. If you raise the issue, it may be a violation. I'd have to look at it as an individual's due process and constitutional rights, because I have to do what I have to do here. But the court itself, quite frankly, is impeding your ability to do that. Something's wrong. There's going to have to be a ruling on it if it's raised. So you are more than free to raise that before me, since I'm the one sending, or raise it before Judge Barr because this is his case. But at this time, I do have a valid warrant. I'm going to take him into custody, sir, so that you know the bond amount that I have here is $2,650 cash.
How much? 2,000?
$2,650.
You got that on?
No.
That sounds like on the civil case, that may have been the judgment amount. And then when you didn't appear for the debtor's exam, that became the bench warrant.
What can I say? How do we get a hold of them?
Hold of who?
The people I owe the money to.
But hold on.
Well,
You got to go with the court officer. And if you got a credit card or somebody you can holler at, you can call for the 265. Maybe you can post it.
not 265, 2,000.
Oh, 2,065. No 10% privilege?
It's a cash bond that normally would come off for a civil case.
So you got to go with the court officer. Make
All
some
right.
calls.
Go with the court officer. Mr. Brown, if for whatever reason he's not released, or there's some difficulty and you can't get before Judge Barr to adjust or do something, I will entertain whatever motion you have, because I realize this would not have happened but for what has transpired over the past few weeks.
Thank you, Your Honor.
You're welcome. We only had to post the one bond. I canceled, so that you're clear, I canceled and just wiped out the 97 one. That may come back to be, but it's from 1997, so it's older than I am. I'm not gonna do that.
Well,
You
Jay,
don't have to laugh. You really did. You could have just let that ride.
I'm sorry.
will JIS reflect the cancellation so that the other court knows?
Yes, because we brought that over from the old system. It's in the JIS system, which you can't get to, but it's in there, and I wrote on there that I'm canceling that one out.
And the sheriff's will. It'll be canceled.
They will not, because they lost their access to JIS when the court did what it did too. So a whole huge mess has been created. I don't know what they're gonna do when they see that I'm putting him in on a warrant. Because to the extent they're able to look up a criminal case, I don't know what they're gonna see the civil. I have no idea.
Can I ask one thing?
Yes, you can ask one more question that I can tell you I do not know, but go ahead.
May I have a copy of the cancellation that you put in the file so I can give it to him?
I just wrote it.
Yeah, but.
I can write it on another
So if
piece
he
of paper.
walks out, and gets pulled over.
Okay, so here's what the problem is. Yes, I get it, Mr. Brown. The problem is that I wrote cancellation on my JIS printout. Supposedly, you guys aren't supposed to have that. I don't know why. It seems stupid. That's a legal term. And so I can't give you that.
You give to him?
No, I can't. I don't think. I had to think it through. To Brown. I don't know that you guys can even do this. This is also what's weird because you guys represent people on criminal matters. If you were to indicate to me that you're the attorney of record or get him to sign something that they would like that information turned over to you, that's fine. You're trying to get some verification that I canceled that warrant.
Yes,
because you can't get to the place that it would be. So here's what I will do. Ms. Weidling,
Yes, Your Honor.
could you type up a document for my signature to present to the public defender's office that I can't, on the 97 case that I canceled it, I will sign that, and that way you have it in writing from me.
Yes.
Thank you.
That took much longer than it needed to. Court calls the case, not because of you, Mr. Brown, it wasn't. Just stupid stuff.
Imagine being
Call me out like that. The prosecutor say something.
Assistant Public Defender Chelsea Vergils with and on behalf of Montel Gatlin, please state your name.
My name is Montel Gatlin.
Thank you. What are we doing?
Your Honor, we are asking to set the preliminary exam in both of these cases. We do not have discovery in one case. I informed my client of that. He does not wish to waive the 21-day timeline in these cases. He asks to set preliminary exam regardless of knowing we don't have discovery on one case.
Which, yeah.
I mean, may I speak?
If you want.
I kind of I don't want her to represent me.
Okay, so you don't get that choice necessarily, but why?
Because just conflict, like we had a back and forth back there in the back room. Like, I don't think she has my best interest.
Really?
Yes.
Why? Because she wouldn't do it you?
Huh?
Because why do you say that? Because I've never known Ms. Vergils not to have a client's best interest at heart. Ever.
By the things she said, this
a lot of things that she said you may have disagreed with, right?
Really all the things.
Okay, all she said. Sometimes that's a lawyer's job. Sometimes they have to give their client the hard facts of what's going on. And they have to do that they have to give them their legal interpretation of what's going on, which may not suit with what you want to happen in the world. But they just give you a steady dose of reality. So if you disagree with her legal analysis, then fine, but show me your law degree.
No, I'm disagreeing with her legal advice.
Okay, and you're doing that with your legal degree that you have, right?
No, she was.
Yeah, that's what I thought.
No, I don't have a legal degree, but
I
she was
know.
trying to get me to waive things. And like I was telling her, it would kind of waive my rights to 180 days into trial, right?
She just got before me. Did you even listen to what she said? She has indicated that you don't want to waive any statutory period. So she listened to what you said. She told me that, and I was going to set these for exam. Anything else?
Yeah, I don't want her on my case.
Well, she's on your case.
Your Honor, I would ask to also address bond if possible.
Yes, you may. Hang on a second. Let me set the exams in these cases. And which case don't you have discovery on that he's trying to set it before you guys get a chance to even look at it? That makes so much sense, but go
We're
ahead.
using media discovery on 25 FB 1090.
On 1090?
Yes, Your Honor.
All right. Discovery on that one is not complete. I'm going to note that. Do people have their witnesses available on the 3rd? Pardon? All right. Preliminary examination in these matters will be set June 3rd, 2025. 9 a.m. That's before me. Right? Those both come before me. They're in person. As to bond.
Your Honor, we're asking the court to consider lowering the bond on case 25 FB 1142. Currently, it's set at $50,000. He's asking you to lower it to the same amount as his other case, 10%. Mr. Gatlin is an Ypsilanti resident. He is employed as a plumber. He at least was before he was in custody and plans to go back to that work. He's involved with his church. He plans to abide by his bond conditions. At this time, he's been in custody for 11 days now, and he is being held until May 29th on a case with Judge Washington. His sentencing is May 29th on that case. So he hopes that the bond will change at that time and that he'll be able to be released. So we're asking you to lower to something he'll be able to pay.
So he's being held on a case before Judge Washington now.
Until May 29th,
What's the proceeding on May 29th? Do we know?
sentencing.
Sentencing. What kind of case is that? Do we know?
I don't know, Your Honor.
All right. Response from the people?
Your Honor, we've asked the bond to stay the same. We think it's appropriate. He does have multiple pending cases at the same time. The case in 1090 is a sole case. This case has concerning elements of that. He's accused of child abuse, but also fleeing police and possessing a firearm. We believe he's both a danger and a flight risk, and we think that this bond is appropriate.
All right. In this case, what I'm going to do is I'm going to deny the request for a bond reduction in this case and leave his bond in place. If something happens on the 29th, before you're, because that'll be about 4 days before you see me. If something happens on the 29th where he's eligible for release, then you can contact my office and I'll reconsider this decision.
Thank you, Your Honor.
Thank you. Versus Jerome Burns. Well, he's in back, right? So we might have to wait. Oh, no, there he is.
And Assistant Public Attorney to carry out the room, Your Honor, on behalf of Mr. Jerome Burns. Mr. Burns, say your name for the record, please.
Jerome Robert Burns.
The people's motion, this was discussed this morning regarding access to the premises.
Yes, Your Honor, I did send that motion to the court and the council. Since then, council and I have been speaking. It's my understanding that the apartment is actually leased to defendant's father and I believe his mother potentially. I don't believe the victim is on that lease, even though that was her home and that was her residence. So I wanted to forward that information to the court. I don't believe that we are in a position where we can ask, for her to be able to stay in that residence since she's not on the lease and it is the defendant's father who is.
Well, I think we're absolutely in that position. I mean, that would occur, that occurs all the time. And the problem that I have with not being able to do it, or at least forcing it to happen, is that you would have individuals that may be potentially victims of, in a domestic violence situation, where the leased premises, which is their home, is leased to somebody else. And then they can't go back there. And they didn't do anything to be sort of on the outs.
Judge, if I may, I think there's a little bit more information that the court should have. My understanding, my client's father is here present, and he was the one that was able to update us on what was happening. The apartment is leased to him and his wife. That has been their home for the past 9 years.
Whose home?
Father and mother, not defendant and complaining witness.
Okay.
Yes, so it's leased to them, but that's their home. And my client and his wife were living with them at the time. They still live in the home currently.
Okay.
And my understanding as well, and it states it in the report, before this incident even occurred, the complaining witness had left the home. She had already moved out of the home. I know that the original allegation or issue was that there was the locks in the home were changed.
Yes, that's what I heard.
That is correct.
Why I set the hearing.
I spoke with Dad about that, and Dad said, yes, I did change the locks because she had since moved out the home probably about a month before then. And later he found out that the complaining witness was entering the home with the keys that she did have while he wasn't home, moving things around. And he stated that he felt it was necessary to change the locks because she was no longer living there.
Your Honor, my understanding is that the victim left because of the physical abuse and fear by the defendant. So she left and sought a safe place for her and the child. So that part's true. My understanding is the same, that she left, however, under those conditions, and I think that is an important addition. But going back to why I don't believe we cannot exclude defendant's father from a place where he's leasing, of course. So in regards to that matter, we'll just ask for there to be a civil standby so she still has belongings there. I of course ask that none of her belongings be touched by the defendant's family and that they cooperate with law enforcement to allow her to come and retrieve those. There's also a matter of the vehicle. So at this point, the concern I have for this victim, and more so for the child, quite frank, is that this child has very serious medical needs. This sexual assault took place at Mott's Children's Hospital. While their child was in the hospital, the defendant sexually assaulted the victim. This victim is in fear of the defendant. She, as far as I know, does not have a home to go to. She, as far as I know, does not have a vehicle for transportation. And we're not just talking about going to get groceries. She has a child who has serious medical needs. And so it's concerning to me that she is not able to take that child where that child needs to go for medical needs and other basic necessities. So she's of course in a very, very bad situation. The two of them are married. There is a car that is, from what I understand, just sitting there, and there are car keys that go to that car. Counsel and I have been speaking throughout the day, and I thought we had an agreement that the victim could use the car since it's just sitting there and she desperately needs it for what they have in common, to be able to do what she needs to do for that child. Since then, I learned that the defendant is not agreeing to that. My understanding is that he has some concerns about the condition of the car. And I'll let Miss Akuri speak to that. But again, my more immediate concern is this child right now. I'm not suggesting we should talk about the ownership of the car, but I don't understand why this victim cannot have access to their joint car to transport the child if she needs to.
And Your Honor, I did have an opportunity to speak with my client. Initially, the client's father, again, was the one who was able to facilitate. He did inform me where the vehicle is, that there are keys to the vehicle. And speaking, he doesn't have permission to give them over, obviously. I spoke with my client. He reports that there is front end, it's not damage, but there are front end issues with the vehicle. It's a work truck. It's a very large truck. It's a Chevy equivalent to, I think, a Ford 350. It doesn't have any of the additional enhancements, but he said it's a very large truck. All of his work stuff is in there. He's concerned.
His work, dad's or?
My client, Your Honor. This is his vehicle. He reports that this vehicle was his prior to. He does not feel that it's safe. Marriage, I apologize, because the people indicated that this is like joint marital property or something to that effect. But this is a work van or truck that he has been using for his construction business. I do not think when she left the home, she left without the truck, Judge. The truck has only become an issue now. And I don't really understand how, if there is an emergency, the truck would really be of any help, because I think 911 would be the more plausible way to go if there's a medical emergency with the sick child. Back to the truck though, Judge. The truck, we don't know.
I guess I don't get this. I mean, I'll let you finish.
Sure.
But these are two people, married and or not married, who have a child together.
Correct.
That has special needs and may require medical care.
Mm-hmm.
For whatever reason, the big people don't get along now. And what I'm hearing you say is that as a father, I'm not going to make sure that the other caregiver of this child at least has some ability to get the child where it needs to go. That's what I'm hearing you say.
That's not necessarily what we're saying, Judge. I think that my client, again, with the mechanical issues with the vehicle, he indicated that it's not safe for her to drive. So it's not the safest vehicle to turn to if you needed anything in regards to transportation. And also, if he was in the process of getting the condition or the issue of the car fixed, and he hasn't been able to do that. So it's possible that driving it any further would possibly make it, put the car in a worse condition mechanically. What else to do?
So, Your Honor, I mean,
yeah,
I'm not here to argue the condition of the car. I understand this is all coming to the defendant. Again, and I want to be very clear that the victim has not asked for access to the car. I reviewed the case. I found that she does not have any transportation. And based on my experience, that is concerning to me when there is a sick child. How that car may be affected, potentially or not, by her driving it to provide for this sick child doesn't really matter. That is not what matters here today. This is an urgent situation. It's bad enough that she is homeless because of the physical assault she endured while having a sick child, The least we can do is give her access to the car for those purposes, and then they can work it out later. I'm not worried about whatever's going on between the two of them. She needs to be able to have some transportation. She has a small child that is sick, and she needs some help.
And Your Honor, my client, he did raise his hand. He just wants the court to understand that he's not trying to keep the vehicle from them. He says it's not a safe car to drive at all. That normally when the child has appointments, the state provides transportation for the child to get to and from his appointments. He has indicated to me that he has transported the child in their vehicle previously, but the wife does not normally drive that vehicle. It's not a vehicle that she's used to driving. She doesn't drive it normally. It's his work truck. And aside from.
So she's incapable of handling what would be.
No, I don't know.
50?
I don't know if she's licensed. I don't know if she's insured on that vehicle. I don't know. She's not. They're just.
Not insured?
She's not insured on the vehicle, Judge, according to what my client just told me.
How does that happen?
It's a joint insurance. So if I would have added her to the insurance, then she'd be able to legally drive that vehicle. If she's not added to the insurance, she legally cannot drive that vehicle.
That's not what he's asking you. Why did he?
Your wife?
Do it.
Why did he?
Really?
insure her in the vehicle?
And it cost way too much money having her insured on that vehicle.
And that's my understanding, Your Honor. Is
Was there a vehicle she was insured on?
When her dad had a vehicle for her, she was insured on that and had received a.
Where's that vehicle then?
That was 7 years ago, sir.
And that's
so for 7 years she hasn't been able to drive.
She's able to drive. She just hasn't. She chose not to.
And that's kind of what Dad told me, Your Honor. Dad just says he doesn't really know her to drive. She's not one that drives normally. She's usually at the house, or they use the transportation provided by the state whenever they needed to take the child to the vehicle. Other than that, my client was the one who would do the majority of the driving.
Your Honor, what we're seeing, I'm sorry, this is the perfect example of the worst domestic violence dynamic you could possibly imagine. The fact that the defendant and the defendant's father are deciding whether or not this victim can drive a vehicle, when she can drive, how can she, I mean, this is.
I don't think that that's what we're saying, Judge. We're just stating facts that he stated that she had a vehicle at one point. She no longer has a vehicle. If she doesn't have a job to go to and she doesn't have any other need to drive, all we're stating is that she does not drive normally. The bottom line on our position, Your Honor, is my client indicates that the vehicle is not safe. Now, we've concluded from him that she's not insured on the vehicle. I don't know the status of her driver's license. So honestly, I think that this is a family law issue. I don't think that this pertains to our case at all. She left the home previously before this case happened.
I want the keys turned over.
You want the keys? No worries, Your Honor.
I want her given access to the truck. She can then make, I'm assuming she's a grown woman, so she can make her own decision as to whether or not she wishes to drive that truck.
Okay.
She can also make her own inquiries as to the insurance that's available on that truck and the like. She can even take it to a mechanic and have them look at it as to its roadworthiness. But geez, she's grown and she can make her own decisions and doesn't have to have defendant dad make those decisions for her. So how are we going to get these keys to her?
Dad says he has the keys. It's not with him right now, but I mean, previously, again.
Them to the public defender's office can get them to the prosecutor's office can get them to the victim. All right. What do we then need to do on this case?
So, Your Honor, initially we were asking for the adjournment. There was a little bit more discovery or investigation, I would say, on our end that we needed to complete before we decided which way to go.
Want the 5th or the 12th, counsel?
I didn't hear you, Your Honor.
5th or the 12th?
Let's do the.
I mean, he's in custody, that's why I'm asking.
Let's do the 5th, Judge, that's fine.
June 5th, 2025. 9 a.m. or as your invite indicate, bond will continue.
Thank you, Judge.
And I have
Good afternoon, Your Honor. Counsel based on behalf of Mr. McFall, who is present to my right. Can you state your full name for the record, please?
Floyd McFall.
Your Honor, today is the date and time set for PCC. At this time, we're going to be requesting to set this for an exam.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available on the 9th.
Yes, Your Honor.
Preliminary examination in person, September 9th, 2025, 9 a.m. That's before Judge Valvo. We've got, you want to address the violations now?
Yes, Your Honor. I did speak with my client about the violation. He did attempt to turn himself in twice, and he was told that there was no warrant. Him and I spoke about it in depth. He understands how serious it is. Your Honor, if the court is willing, maybe to put him on a scram tether, and he will have no further violations in this matter. He's just asking for one more chance, Your Honor.
Response from the people.
Your Honor, we have concerns about involved with drinking. I would note that it's not just one incident, it's on 2 different days. And that the report indicates that when Mr. McFall was questioned about the August 19th date, he admitted drinking, but then we have an August 24th date. So,
and also an August 26th date. It's on, that was, you may not have, well, you should have. There was one report on August 20th, which has those 2 on it, I think. Maybe not. No, the 19th, and then he drank on the 24th, but then further down, he also then blew and numbers on the 26th. But there aren't any other readings because he didn't take the follow-up test.
and so, Your Honor, part of the reason that we find it concerning, believe that alcohol may get involved with this, and that as far as the felonious assault charge, the alleged weapon is a wine bottle. So that's what gives us some concern. So I don't see why an alcohol tether is going to somehow ensure that Mr. McFall applies with bond conditions that he seems to have violated them multiple times when he was confronted.
Well, Your Honor, in response, although a wine bottle is allegedly involved, that's because these allegations took place at a store. He was not drinking at the time. There was no, I don't believe there was an alcohol test taken at the time of arrest. So there's not really a substance abuse problem involved. And I would say that the tether would be a constant reminder that if he does end up drinking, he's going to be remanded.
So blowing into a machine doesn't do that?
Well, Your Honor, I think the tether on his leg is and I've had serious conversations with him, Your Honor. He's just asking for one more chance. He is here today. He understood that there was a warrant for his arrest. He still came in. He did try to turn himself in a couple days ago when I originally told him that there was no bond warrant. He does want to move forward, Your Honor. He's just asking for another chance.
3 occasions. Is he in any treatment or anything at this point?
No. Just at my church, I don't have proof for it though. And I did sign up for AA. I took like a hour-long test on it. I just got to get into.
Okay. Well, it looks like he is working on that, Your Honor. He's signed up.
Working on it.
Yes, he's signed up for treatment.
Between drinks. Bond revoked. Defendants remanded. Your name?
Melissa Kalwinski.
All right. What are we doing on this case?
Your Honor, we're asking for an adjournment for negotiations and to review videos.
You've seen the bond violation report?
Yes, Your Honor, and we have discussed it and I'm ready to address it when the court is ready.
Yes, I'm ready to address it.
Ms. Konowinski stated that she did drink, but it was only that one day. This was a one-day slip-up. She didn't take the test within 15 minutes because she fell back asleep. She takes mental health medications at night, which has been reported to CMH, which make her fall asleep. She wasn't avoiding calls. One of the numbers that she gave was her boyfriend's number, and he said that he didn't receive any calls. The other number no longer works. She did believe they have her current number, but that phone only worked on Wi-Fi, but she recently got it switched to a phone with a SIM card, so now works all the time. This Saturday, the 30th, she returns to work at Dunkin' Donuts. On the 11th of September, she will start a part-time inventory job. She also receives her Vivitrol on the 11th. On September 22nd, she has an appointment for mental health addiction recovery and an evaluation with IHA Trinity Health. She has been going to AA and has proof. Her letters of recommendations from
How long has she been going to AA?
She has the proof. How long have you been going?
I've been going over a year. It's a sunshine group. But since I've been out of rehab, this is what I have.
When did you get out of rehab?
I got out on the 15th,
Of what?
August.
And she does acknowledge that
Instead of drinking by the 19th.
that was one day after. And since then, she has been testing negative. She has letters of recommendation from Bear River Health and one from her boss. She volunteered in Hanover, Michigan at Rust and Dust and has a letter from there also. She realized she slipped, and for the first time, she wants this court to know she caught herself and immediately got back on track. And normally when she slips, she goes on a bender. Ms. Konowinski is asking for more time to test instead of twice a day so that she is more accountable to herself and to the court. We ask this court to recognize that she had no violations after that date and to give her another chance, especially since she has appointments set up for her mental health and for her addiction. She is also here today knowing that she could be remanded. She would also like to address this court.
Good morning, Your Honor. I first off want to thank you for back in December of evicting me from my ex's house. I'm glad that you did. I did not want it because that was a safe spot to drink. And since being evicted, things have changed. It's come into a lot in my life. I don't have to be in that household with him. And for that, I thank you very much. During the eviction, I was scared because I was giving up my way of drinking. And to this day, if I would have still been there with that man, I would probably be dead. So I thank you for giving me the eviction. And I do acknowledge and admit my part in this addiction and what I did. I'm not saying it was right, but I want to be fully honest with my recovery completely with sobriety because I don't have any more to give.
Response from the people.
This is an overview I heard with 2 priors, both in 2021. This was a hit and run crash where the defendant was then located driving a vehicle with heavy front-end damage. She was so intoxicated they couldn't even do the field sobriety test. Eventually, her blood test showed she was a 0.280. I have no faith that she can be safe in the community right now. I'm extremely concerned. And Evo and described Heather, given the levels that we see in the SoberLink testing. And I also know from the court, I'm sure the court's already seen it, it's towards the end of her testing window. So that leads me to have suspicion about what was it earlier in the day. I'm extremely concerned for public safety. Should she be released at all? I would ask that her body revoked and she be remanded. If the court is inclined to release her, I would absolutely request a scram tether. I don't think SoberLink is going to be sufficient for public safety.
And Your Honor, I think she would be okay with that if she did ask for more times to test so that she could be more accountable to herself and to this court.
And Your Honor, I have to back that. I don't think more times to test is going to be an adequate solution here with somebody that's at a 0.28 crashes, runs from the scene and has 2 priors.
Let me clarify. I was saying that she would be okay with the scram tether.
She's currently in some type of program?
She starts her program on the 22nd.
IOP intensive outpatient.
IOP intensive outpatient.
When?
September 22nd. She starts testing.
Do I have that? Is it somewhere in writing?
I have it on that.
She emailed it to me. I can send it to the court.
Well, You can send it to the court along with some order. There's got to be some structure. If she's not going to be in an IOP, I can't take the chance that she's going to go on another one of these, hop into a vehicle, and this time take somebody out. I can't do that.
Well, Your Honor, she has been negative, and that was just the one day slip up.
Yeah, but that's all it's going to take.
I understand.
She's got, this is her third.
I don't have a vehicle.
She is.
Don't have a car. And I'm going to church and I'm doing AA and I volunteered. And I know what it looks like, but I wish people could see why I drink. To see the abuse and to see everything I went through. Well, why the hell I was living in.
I get all of that. The problem is that what's going to happen outside of the alcohol, you could potentially end up killing yourself just from the alcohol. But then all it takes is one of these slip ups and somebody else goes, somebody who had nothing to do with any of that abuse, had nothing to do with anything. They're all of a sudden wrapped into your world and your tragedy that you've been suffering. I get it.
I understand that, but I haven't drove in over a year or 2 years. I'm willing to go with alcohol tether, and I'm fine with that, Your Honor.
And Your Honor, she now keeps in contact with me as a support system. She calls me weekly and we talk.
And I have like letters.
Got to put together something. I'll consider it next week in terms of programming or something like that she's involved in.
Okay.
But
I do have IOP set up. I do have it set up with Medicaid rides and everything. I've been really working hard since I've been out to get back on my feet.
Going to happen again. Defendant's bond is revoked during the probable cause conference, September 4th, 2025, 9 a.m.
Yeah.
Okay, September 4th, Your Honor?
Yes.
Thank you, Your Honor.
Your Honor, today is the date and time set for probable cause conference. At this time, we're going to be asking for an adjournment to continue negotiations, as well as give my client some time to hopefully pay off the sum of the restitution in exchange for a better offer.
Before I set the date on an adjournment, she has a no bond warrant.
Yes, Your Honor. As to the violation, Your Honor, my client still has the tether on her, leg. As to the explanation, Your Honor, she tells me she was riding her bike and the tether got caught in her bike, and like with the pedal, so she kind of had to adjust it. She lives far away from community corrections. That's why she wasn't able to go in and get.
I have a broken phone too. I had my number to the tether guy in my phone, and I had no way to contact.
So the tether came off in a pedal.
No, it's still on. It just pulled it and it poked it. Like there's something poking through it.
Did you call community corrections at any point?
That's what I'm saying. I was able to. I didn't know who to call except for the tether officer, Mr. Levitt, but it was saved in my phone.
Was your tether going off?
Broken. It was going off, but I was on my bike and I was kind of scared, so I wasn't sure where or what to do. I did call my mom right away. As soon as not call her, but I went to her work. I rode my bike to her work actually, and tried to use her phone, but I wasn't able to while she was using it for work.
So if you didn't know where to call, what were you going to do with her phone?
I was going to call the public defender, which I did. I was able to email someone that following Monday because it was on a Friday, but I did text Hannah Mackey from the public defender that night when I was able to use her phone, explaining that there was an issue and that I didn't have a way to contact. And then when I did finally get a hold of him, and left a message out until tomorrow, I think, but I was waiting for someone to contact.
Did you go to the community corrections?
I called them. I did when I finally was able to figure out who to call when I got the email.
When did you call them?
I called.
How many days after this alarm went off?
Well, it happened on Friday, and then I got the number to call the community corrections that following Monday. I called and left a message for Mr. Levitt. I think I left the message actually today.
Your Honor, I just want to say that this is a tether was put on because I believe for a previous failure to appear, and she is here today, Your Honor. So it shows that she does want to comply with the court order. She does want to be here. She does want to handle her case.
But she
Contact.
doesn't want to comply. Have you been to community corrections at all?
No, I live in Jackson. I was lucky to get here today. I wasn't even sure what was going on. I don't have a vehicle, and or a phone at the moment, so I was requesting things through email as well, or trying to. I'm still charging it as well. Like, I'm not trying not to.
She's not
go
trying
through
to
with this.
she's not trying to abscond, Your Honor. She's not trying to disobey the court orders. It was just, it seems it was just an accident. And just due to her lack of efficient communication method, I think that's really where the problem lies.
I have an old tablet from 2015, I think, with Wi-Fi for communication right now.
And when I reached out to her and let her know that she would be required in person because she initially tried to attend via Zoom and put in a request via Zoom, she did her utmost to make it here, and she's here, Your Honor. So
Yes, but I don't
Don't have a
understand why she didn't.
she hasn't even secured a ride back yet today. So
Yeah.
she her
But
transportation.
why she didn't keep in contact more with community corrections?
I think it's due to
I mean,
her
this
lack
thing
of.
went off almost 10 days ago.
Well, I was
And
waiting.
we don't-
I'm sorry.
Go ahead.
I apologize. I was waiting for someone to get back a hold of me through my mother's phone or through email because I wasn't sure, and I was still charging it. So I honestly just assumed everything was okay. I know that sounds stupid when I say that out loud, but I didn't know what else to do as far as contact. As soon as I found out the information this morning, I did everything I could to make sure to come. And left another message on Mr. Levitt's voicemail, who will not be in until tomorrow.
The second page and what they suspect this defendant was doing is really alarming to me.
I'm not sure what that means.
Your Honor, I think that is mostly just speculation at this.
Oh, I
point.
don't-
She still has the tether on. She's still been charging it. She's still.
What is?
And I don't think there's a hot zone to this tether, Your Honor. I think it's just a GPS tracking tether to make sure she comes back from court, is what I understood. And she is here today. So the purpose of the tether is being fulfilled.
Any response from the people?
Your Honor, when the court released this defendant in April of this year, the court gave her a chance. I had expressed concerns because she had 2 warrants out of Kent County, one for child support, one for an OWI third, if I recall correctly. And I was worried about seeing her again. The court gave her this tether as to track her location. So it is the people's opinion that strict compliance with the tether would be a condition of bond. So any tampering, anything like that. I noticed when the defendant was giving her recitation of what happened, she first said, I called my mom, and then very quickly said, I went to her work. Because she earlier had said that her phone wasn't working. So that is concerning to the people. It's something I picked up on. I think the court picked up on it too, as I
Yeah, I did.
So I'm just worried about what's gonna happen.
I don't think I'm being told the truth, in all honesty.
I understand.
Your Honor, I understand, but as I said, the purpose of the tether was for her to come back to court. I'm not sure why there's concerns if she's in court here today. And she's saying that she just misspoke because she's very nervous, Your Honor. She suffers from anxiety.
Probable cause conference will be adjourned to September 4th, 2025, 9 a.m. Defendant's bond is hereby ordered revoked. Defendant's remanded.
Here was closed.
Court calls the case of the people versus Richard. His writing is horrible. Scribner.
That's
the sound of an American oil company.
Case because you wouldn't sign the consent order for me.
Because it's inappropriate.
Well, I
So
showed
I
it's
will,
inappropriate
it will
keeping it to
be
one-
denied. Don't do that, counsel, because you don't want to go there with me. Not today.
Thanks for checking in, Ashley.
Oh my gosh, I'm so sorry to hear about that.
All right. 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge
Make a decision.
Yes.
Court does call the case of People versus Elizabeth Wilson.
Good morning, Your Honor. Ashley Lundy, Feltus for the people.
Good morning, Your Honor. Attorney Michael Kelly, 77187 on behalf of Ms. Wilson.
Your name, ma'am?
Elizabeth Wilson.
All right. Date and time that the court had set for a restitution hearing at the request of the defense. I also have a motion to withdraw, which seems rather weird to me. So, wherever you'd like to start.
Your Honor, just in terms of the motion with withdraw, I did submit that request in advance, hoping that we would have the opportunity to be heard on that prior to today's hearing, not to cause any prejudice to my client. I am here, Your Honor, for today. I think it's the most efficient use of my time that I'm going to stay on with Ms. Wilson for purpose of the restitution hearing, since I'm already here.
Well, just so that we're very clear, and the reason the court did not sign the order is because the restitution hearing, particularly at your request, is part of sentencing. And I would not permit counsel to withdraw in the midst of sentencing. It just would not happen. So, it's good that I don't have to deny the motion, but I wasn't signing it, but all right. So it's withdrawn. What are we doing with regard to the restitution? In my understanding, the victim is here via Zoom.
She is here, Your Honor. I wasn't sure. Thank you, Your Honor.
Well, that's what I think I was informed of that. Ma'am, are you here?
Oh, yes, I am.
Yeah, okay, there you are. Okay. Thank you very much. All right, What are we doing?
Your Honor, has the court also received the estimate that was provided by Michelle Miller reference from Great Lakes Collision Frame for the repairs?
The one that is 2029.08.
That is correct, Your Honor.
Yeah, I do that.
So Your Honor, we could proceed to the hearing. I'm not sure if defense counsel, now that Ms. Miller is here, is willing to stipulate to the rest of the matter, if we do need to have a hearing.
We're here for the hearing, Your Honor.
Your Honor, will the court allow Ms. Miller to testify via Zoom?
That is how she's appearing. So yes, I
Ms.
will.
Miller, are you able to testify right now, or are you busy with something else?
I'm working.
Okay. Is there a point, Ms. Miller, that you're going to have a break or a point where you can answer?
In about an hour and a half. In about an hour and a half. In about an hour and a half, I'll be done with this head and I'll have this client under the dryer.
Got it. And then you'll be able to take some time and testify?
Yes, sir.
Okay. Then what I'm going to do, said about an hour and a half. What is it? Okay. All right, because her testimony is needed.
Can we have just a moment to confer with defense counsel to see if that's gonna work?
Yeah, Your Honor, I didn't block off a whole day for.
Well, counsel, you're in this case. Whether you blocked off a whole day or not, is irrelevant to me.
I'm in this case because you wouldn't sign the consent order for me.
Because it's inappropriate. It is inappropriate to ask to withdraw in the midst of sentencing.
It's not.
You have no authority. Do not interrupt me. You have no authority to show that that is appropriate.
Well,
it will be denied. Don't do that, counsel, because you don't want to go there with me. Not today.
Judge, I am being respectful as possible.
Court recalls the case, People, State of Michigan versus Elizabeth Wilson.
Right.
Good afternoon, Your Honor. Ashley Lundy, Feltus for the people.
Good afternoon, Your Honor. Michael Kelly, P77187 on behalf of Ms. Wilson, who's present, standing to my right.
Elizabeth Wilson.
All right, what are we doing?
Your Honor, at this time, I believe my client is prepared to stipulate to pay the restitution.
Your Honor, do I have to pay the full amount?
I'm sorry, go ahead. Well, hang on a second. All right, here's what I'm gonna do, and then I'll answer your question, okay? I'll order restitution in the amount of $3,029.08, okay? And then my next, when you say, do you have to pay the whole amount? What are you asking me, ma'am?
Well, I've been advised that this is not a trial and I need to get my paperwork, please.
Okay, go ahead.
Due to the fact that I'm the only person that was there, she was driving a Cadillac. She wasn't driving the vehicle that has been stated in the police report. Also, she did not wait for the officer to show up so the officer could look at her vehicle. Anything could have happened to her vehicle from the time that she left Wendy's and from the time she got home. And then I didn't receive a phone call from the officer till 4 or 5 hours later, stating the fact that that this had happened. And all she had to do was send pictures over. And that justified the fact that I hit her car when I didn't. I would have stayed if I hit her car. It's what car insurance is for.
Hold on a second, ma'am.
Mm-hmm.
Okay, can we? Go ahead.
Sitting on the drive-through, there's just no way I could have done that kind of damage. You're sitting still. It would have affected.
Ma'am, let me just stop you. And I know you got something you want to tell me. Hey, but there was, but I read it. There was a no contest plea to these charges.
Right.
And now you're disputing them?
I took that because I was not informed that I had to pay restitution. I took that because that was the cheapest way out.
So, okay. Go ahead.
That's okay. Thank you very much for your time.
Is there anything else? I mean,
there's no proof of anything and it doesn't make sense to me. It really doesn't. I mean, the officer wouldn't look at my vehicle. I offered to bring it in, like I've been cooperative.
Right. Well, but understand that the only thing that I'm going to know when I'm looking at this, because it was a no contest plea, is what's contained in the report. And as part of a no contest plea, I accept what's in the report is true in terms of making a finding. Now, where you got the information that restitution may not happen, I don't know, and I'm not getting into that. I will just say that when something like this happens, the issue of restitution, a lot of it is statutory, it just occurs. Okay? So going back to your initial question of the payment of the restitution. Now, how can you pay that? Let me ask you that first.
I can't. I don't have a job. But, it's the law. I've always followed the law, never been in trouble with the law. So, I mean, I just thought maybe you would take in consideration the fact that there's no proof. I mean, she just sends pictures over.
Okay. So here's the thing that you have to understand about this, and that's why I keep going back to the no contest plea. Once you enter that plea, then Miss Miller basically becomes a crime victim. And pursuant to the statutes, then she's entitled to restitution. That's a simplified version. Okay. So in essence, she's entitled to be made whole. Yeah. in terms of restitution, and now that it's been stipulated to, I don't know that there's much the court could do. It really becomes an issue of how it gets paid. And it's also so that you know, because I know you've been in the courtroom with other cases, I'll try to work with people, but I have less flexibility with the issue of restitution. In fact, in a lot of ways, I have none. I can set it up so that it's paid over time, certainly, but I can't waive any part of it. I just, my hands are tied in that respect.
So I needed to go to court and prove all that stuff in order to avoid paying this then, right? That's what I needed to have done. Going to trial.
Ma'am, I can't answer that.
I know, I'm sorry, I'm not getting any answers, so I'm coming to you.
So, well, because there are so many, the reason I can't answer it is because there are so many reasons why somebody may not go to trial or goes to trial. There are a whole lot of different considerations that play into that. So if it were a simple yes or no, and I had an opinion about it, then I'd tell you, but I can't, in all honesty, say that.
Okay.
Okay.
Well, thank you for listening.
Not a problem. So in regard to the restitution, do you know how you're gonna get that paid or how you're gonna pay it?
I'll figure it out.
Okay, so, but I got you. But I need to sort of put something on it to say how you're going to do it.
It's $50 a month, according to my probation right now.
Pardon?
$50 a month.
$50 a month is what your payment plan is to us.
Yes.
Your Honor, that's for the fines and costs.
Fines and costs. All right, why don't we do it this way? Because you say you're not working right
No, I have a job, but I just applied for it and it takes another month to see if I get it, so.
Got it, okay. So, Ms. Polero, why don't we do this? Have you made any of the $50 payments yet?
Yes, I've already made 125.
That was on
another
the
50.
date of sentencing, right?
Right.
Okay. And then, so then your next payment was going to be the 50.
Right. I'll make that today when I leave.
Okay. Are you making that in cash?
No.
Okay. So here's what I'm going to do. Let's set. You have her review is February 24th of 2027. All right. So here's what I want. The $50, so you'll need to pay it in cash, right?
Like come in here and actually pay it?
And actually pay it.
Okay.
The reason I'm going to do, you have to do that is because I'm going to have what you can pay in terms of the $50 go to the restitution.
Oh, okay.
Okay. But I can't do, if you were going to pay it on a card, I can't do it that way.
Okay.
Okay. So it's got to be cash that you come in and pay.
Okay.
All right. So I realize you set up a payment plan. She's now got this balance. It's going to be $50 per month until probation tells you otherwise. If you get employed, then it may be something else.
Okay.
Got it?
Yep.
And you just have to pay that in cash. It's to go to the restitution and then be paid over so that balance can go down. Make some sense to you?
Yes.
All right. And then we'll do it that way. So I've ordered it. It's payable through the court in accordance with what I've said and at the direction of probation.
Okay.
All right. Thank you.
And Your Honor, lastly, I just want to make sure that my appearance is being removed as attorney of record from this point forward.
File an order requesting that you be removed as attorney of record as one would do at the conclusion of a certain point, and the court will sign it. Thank you.
Thank you.
What is that?
It's 12 o'clock. Technically, it's only 10 cases.
Why is Paige looking at me that way?
10 cases.
She's ready to go.
They're all show causes.
They're all show causes.
Yeah.
If you're involved.
It's not right. It's their lying.
Stop.
The blood
Stop.
of Jesus.
And I am not a nasty woman.
Hold on, we're having technical difficulties again.
People State of Michigan versus Anthony Blake Hamilton.
Robert Agasinski, appearing for the prosecution, Your Honor.
And good morning or good afternoon, Judge, to you and your staff. Robert Burton Harris on behalf of Mr. Anthony Hamilton, who is also present in the courtroom.
All right, date and time set for preliminary examination. Are we ready to proceed?
People are ready to proceed, Your Honor.
Well, I think that depends on who you ask. So me and brother counsel have spoken, and it seems that the complainant, who is the subject of the charging document, and also the main complainant in this case, is not here. And brother counsel believes that he can proceed with the testimony of the wife. We disagree on that because
wife,
the complainant's wife was also present. But this is our position is that this is an assaultive case, and I don't know how the wife would testify about her husband's level of fear or feelings of being assaulted. Because in this case, the complainant witness was not assaulted. So I don't know how the wife would actually testify to that, but brother counsel can speak to that, I guess.
Certainly she can testify as to what she saw.
Yes.
That's correct, but I think that if
there's, quite frankly, if there's then a dispute as to what his feelings may have been or anything along those lines, and I'm not saying that the court's ruling that, but that may be an issue of fact for the fact finder, which would have the matter proceed. So are we ready to go?
We're still ready to go, Your Honor, with what we got.
All right, you can have a seat. Start calling your witnesses.
Yes, sir. They're out sequestered, I think, at this time. So I think I will call 4 during the exam.
All right, who is your first witness?
When curiosity strikes.
Yes, this is my first one. Miss Lynn? Thanks. Come right up.
Then please come forward and be sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God. Go have a seat. State and spell your first and last name for the record.
Why you got, you live in Berlin, why you got calling you live a life?
All right.
Is that loud enough for the court?
Pardon?
Was she loud enough for the court?
Yes, she was.
Thank you. Again, what is your name, ma'am?
Feeling in Berlin.
And Miss Lynn, do you know who Mark West is?
Yes.
How long has he been your husband?
16.
Okay, he was your husband on October the 28th of 2024? What does your husband do for a living?
He is a professor at University of Michigan.
Okay. Now, did you and your husband on the date of October the 28th of 2024 go together to a Kroger parking lot located at 2641 Plymouth in the city of Ann Arbor, Washington County? Do you remember about what time you actually arrived at the parking lot?
It was dinner, so probably around 6 before 7.
Okay. And was it dark at that time or still daytime?
It was dark.
Okay. Did anybody go with you besides you and your husband? Okay. And were you going to the Kroger or one of the other stores in that mall area? Okay. And did you get out of your car and did you park the car and get out of the car? Okay. And what happened after that?
I drove, so I'm in the driver's seat, so I'm looking at my phone, and then I turned and looked over across the parking lot. A car was coming by as my husband was going to cross over, drive to go to Kroger. But the car came really close to him, where I think I may have seen his hand like, whoa.
Objection, speculation if she said she thinks she saw something.
It goes to weight.
That goes to weight, yeah. Go ahead. Overruled.
And then the car came in, and I think that really like took my husband off guard. So I saw him come around.
Around where?
Back towards my car, where this car was pulling in.
Okay, your husband was walking away, had some interaction with this car, and then he came back to where you were.
Yes.
Then what happened?
He was wanting to say something to the
Objection.
gentleman.
I'll sustain that objection.
Okay. Yeah, we don't want to have you testify to what he was thinking. If we ever get to him, he can tell us that. Just what you saw. So what happened as he turned around and came back to you, toward your direction?
The car very quickly parked in his face and got out. The gentleman got out.
Okay, the car that had some kind of interaction with your husband?
Yes, was my husband. And the gentleman got out and said something. I saw them speaking to each other. At that time, my husband pulled out his phone and wanted to document something.
Okay, so you saw your husband pulling out his phone?
Yeah.
Okay.
The gentleman was being very aggressive. His body language was very aggressive towards my husband. At that time, I got out of the car. And then I said to the gentleman, "You almost ran over my husband." The gentleman, because I don't remember exactly what he said. He said something, also took out his phone as if, okay, you're gonna film me, I'm gonna film you too. Then he took off into Kroger.
Took off into Kroger?
Yes.
Okay, and was that close by, Kroger, to where you were?
Oh, no, because we were kind of maybe 20 cars into the park.
Okay. When you had a conversation with this young man, was it at the back of the car that he had parked?
Yes,
Do you remember what kind of car that was?
it was a light colored, like a 4-door.
Okay.
I don't know what it was.
I mean, you say young man, how about how old or young are we talking about?
I want to say 30 to 40,
Okay. Do you remember what he was wearing?
something dark.
Okay. So you and he and your husband all had an interaction, and then the man went into Kroger.
Ran into Kroger.
What happened then?
And my husband said, he almost ran over me. And at that time, he spat on his face. Because then I had to get out a Clorox wipe for him to, because he was in his glass and it was like all over his face. So I wanted him to wipe it all off.
So who spat on whose face?
The gentleman did.
Gentleman did what?
That almost ran over my husband.
Spat on your husband's face. Okay. At what point did he do that?
When he was exchanging words with him and when I saw that some interaction was happening, I got out of the car. So that had already happened.
Okay, so you saw your spittle on your husband's face and you gave him a Clorox to wipe it off.
Yeah.
Then what happened?
Then at some point, my husband said, he almost ran me over. And I said, I know, I saw that. And I was helping him, wiping everything off. And to me, I had the phone, I should have been videoing everything, but I didn't. Then a gentleman came out of Kroger as we were, and then my husband said, I'm gonna call the police. So he decided to call the police at that time.
Okay, they said the gentleman came out of Kroger. Was that the same gentleman that went into Kroger? And when your husband said he was gonna call the police, was that before or after the gentleman appeared coming out of Kroger?
I think the gentleman came out and changed more words, and then he said, I'm gonna call the police right now. I'm calling the police.
Okay.
Then the gentleman said, go ahead, you call the police.
Okay.
And then he got into his car, slammed the door, decided to back out.
Who did that?
The gentleman.
Okay. Now, where were you and your husband at the time that he got back into his car and began to back out?
We were on the driver's side of his car because there was not a car parked on the driver's side of his car. And then my husband said, no, you can't. Yes, dumb. He was dumb. He actually went behind the gentleman's car and tried to stop him, thinking that if he stood there, he would not back out. But no, the gentleman put it in reverse and then proceeded to back up quickly. So
Okay.
then he had to jump out of the way.
Okay,
He being your
My
husband.
husband, yes.
okay, then what happened?
Then the gentleman in the car that almost ran my husband over decided, I said, honey, you gotta move out of the way. He decided to drive and swerve, almost hit my husband.
Now, you said your husband was behind the car
Yes.
and had to back out of the way when the man backed up.
So now we're on the left side of his car,
Okay,
right? So he backs up and then he decides to intentionally making it look like. he's
Objection after intentional.
I'll sustain the objection, but you can tell us what you saw.
and what did you see? No, what did you see?
Then my husband had to swerve out of the way and kind of bumped him on his hip.
When the man
Switch to TurboTax.
backed out and began to go forward again, how would you describe the movement of the car? Okay. Okay.
He sped out of the parking lot.
Okay. Now, have you yourself ever seen a video of that incident during the police investigation? Okay, I wonder if I could show you. This, I need a few moments to set up, Your Honor. People's proposed exhibit number one.
All right.
My tech is way low.
Okay, that's fine.
So we're going to use this computer. So Ms. Lynn, in a few moments, I'm going to have you look at a video. Will probably be on the screen.
Okay.
And then when the video is done, I'll just ask you, I'm going to ask you if that video depicts the incident you just described accurately. Okay? And that'll be my last question.
Okay.
Okay, for the record now, we have the video, people's proposed exhibit number one on the screen. So you had a chance to look at the video so far? And did you look at the far left of the video?
Yes.
Did you see a car?
Yes.
Did you recognize that car?
Yes.
How did you what did you recognize it as?
That's the car that went right for my husband.
Okay, that's the car we're talking about that you played was involved with your husband.
Yes.
It was on the right of the left of the video as we're looking at the screen. Okay. Okay, we're playing the tape again. Second. So did you see a person running across the screen?
You said it yes.
Yes.
Okay.
And do you know who that was?
Yes, it was John, I think that tried to.
So that was the gentleman you think was involved with
Yeah.
interacting with you and your husband. Okay. Let's go again. It just falls back. Yeah, excellent. Yeah. Did you see a few minutes ago the gentleman running back again? Was that the same gentleman?
Yes.
Okay.
If that's forward a little bit.
No. So
Like up here?
Yeah.
Yeah.
Now we see a white car with the taillights on. Is that the car that we're talking about? Okay. Did you?
He's in the store, so I'll have to walk back.
He's not in the store.
He is in the store.
Oh, I think it's okay.
No. He was in the store for a couple minutes.
Okay. We're fast forwarding a little bit.
Yep.
I didn't see it. Didn't see it. Did you see it? Did you see your husband get hit? Yeah.
Right on the right.
Back that up just one moment. See that again.
Think the incident? Yeah, I did. I just sent it
I
back.
just did because the white truck pulled in. I see.
So that's the, her husband that was just behind the pillar.
Can you get a little closer?
I.
I'm trying to see if you can. Is that your husband's voice?
Yes.
Okay.
I don't know.
Is that enough, Your Honor?
Yes.
What happened after that? I guess I have a lot more questions. What happened after that? After your husband went, what happened after that?
Well, because he's trying to get out of the way of a car that's trying to run him over.
Objection.
So he,
Cop.
Sustained.
What happened
Part of her.
between the two of you then after the car?
he got up, I helped him up. And then we waited for the police to come. And another gentleman came who happened to be a witness.
Okay. Now, he was in the store for a couple minutes, was he not? So what were you and your husband doing during that time?
He was talking to the police.
Okay, on the phone or in
Yes.
person? Okay. And did he give the police the license plate from the car?
I believe, yes, I believe he took a picture.
Oh.
I'm not sure.
That what he did with his camera, took a picture of the license
Yes.
plate? Okay. Did he get medical attention after that? Where was he hurt?
Well, he just fell, right? So just very light.
Bruises, you mean? Yeah. He didn't stay overnight at the hospital?
No.
Okay. Now, did there come a time after this incident happened that the police called you down to the police station to see if you could help identify who the young man was? And what did they do when you went down to the police station? What happened there?
Sent us separately in different offices and gave us a series of pictures.
Separately, you and your husband were,
Yes.
you're separated?
Yes.
And you were told to look at some pictures?
Yes,
Okay. Did you identify any of the pictures?
one.
Did you know whose picture that was?
At the time, I thought it was the person.
Okay. At the time you asked how certain you were, didn't you?
Yeah,
How certain did you say you were at the time?
70%.
70% certain
Yeah.
of the picture that you identified as what? Identify this person as what?
As the person who tried to run my husband over.
Okay. Had you ever seen that person before that date?
No.
Okay. I have no further questions.
All right. Cross-examination.
You want this up here?
No.
Imagine being able to build an app with your name on it, just by thinking about it.
Where were you and your husband coming from when you got to the Kroger?
Chinese restaurant across the street.
Across the street? Does that restaurant, do you frequent that restaurant often? Do they sell alcohol?
Yes, I do.
Did you or your husband have any alcohol that night?
No.
You also testified about you hearing your husband say some things on the video. Is that correct?
On the video, which part?
Any part?
Well, I heard him scream. Yes.
That's not the
Okay.
That's not the only thing that you heard though on the video. Is that fair to say?
Maybe I heard someone talking. I don't know if it's my husband.
You heard the other guy that you described as your words trying to run your husband over, right?
Yeah.
And he was screaming, right?
In my car or in the video?
In the video. In the video that you saw. Well, let's back up. On the night in question, when you were there, you heard the person that you accused of doing all this stuff yelling, correct?
Changing words with my husband, yes.
Is it fair to say he was yelling?
I think I said they were exchanging words. I don't know if they were yelling.
You couldn't hear what they were saying at all.
I was in the car.
So you said that you got out the car when you saw the initial confrontation with the guy and your husband, correct?
In the car, yes. The initial, yes.
And at some point you got back in the car?
No.
So you stayed outside the car from that point until the whole thing was over? And while you were outside the car, did you not hear the other person saying, "Get away from my car. Why'd you hit my car?" You didn't hear that?
I was busy trying to tell John that he was trying to.
You also said that your husband tried to stop the person from leaving, correct?
Yes.
How so?
Just by telling him.
He didn't physically try to stop the person from moving the car at all? Are you sure?
You're talking about when he backed up?
At any point?
The only time was when he backed up, was trying to leave the scene.
So the other person comes back to the car, correct? They get in the car. You and your husband are standing right next to the car.
Yeah.
Your husband.
He's calling the police. He's on the phone, please, right now. Don't go anywhere.
So he's telling this person not to leave. And while he's doing that, he's reaching for his door handle, right? He didn't try to touch a car at all that you saw? Well, I'm asking about what you saw.
I didn't see him.
You didn't see him do that, or you didn't see him at all?
I did not see him do that. I was there the whole time.
At this point, when the person is getting back in the car, tell me specifically where you all are standing.
Next to his car on the driver's side.
Both you and your husband are on the same side. So your husband gets behind the car. Did the person driving the car just hit the gas and run your husband over?
He was backing the car up as if there was nobody behind him.
As in quickly?
Yes.
So did your husband have to like jump out the way to move?
Yes, I told him to get out of the way.
As the car was backing up?
Yes.
Are you sure about that?
I said, honey, you have to get out of the way.
What I'm asking about, are you sure about, is your husband having to jump out the way while the car was backing up?
No, he had to jump out of the way when the car tried to run him over.
So when he's in the back of when the car trying to back up, your husband is blocking him from leaving, correct?
Yeah.
So you convince your husband to move, right?
Yeah.
And at that point, after he moves out of the way, where does he go in relation to the car that's backed up?
The car is backed up. We are standing on the left front side of the car.
The left,
In the parking space.
the left front side of his car. Are you talking about the person who you?
Passenger side.
So you're not directly in front of the car, but you're on the front passenger side in the front of the car. And that's because your husband is still trying to get him not to leave, correct?
Yes, he's still on the police at the time, yeah.
So after the car backs up, does the car back up and then straighten it all, or just backs out of the parking spot?
The car is parked like this. He backs out with a little bit more room. We're standing right here. And then when he hits the gas, then he can swerve to hit us.
So he didn't drive forward and then have to turn left to go out of the parking lot. You're saying that the car specifically swerved to the right.
Yes.
Judge, the video you've seen, I can replay that, but it's just zoomed in, so I think you can get a better view if you think you need. Needed.
I don't need it. I mean, I can see that. I will tell you if you think you need to play it for me, but what's clear to me is that there is a pole that is obstructing one of the poles from Kroger. But I can see the left side and also what appeared to be part of the area behind, which would seem to me whatever the vehicle, whoever was in the vehicle had more room to pull back and straighten themselves out. I can also see that the vehicle does have, to the extent there is a swerve, I don't know that I see a swerve. What I do see, however, is I do see an individual heading down the right side of that lane where there appears to be plenty of room to the left. That is what I see, but if you want me to see something different, then play your video.
Nope, I think that's good enough, Judge. You also say your husband wasn't injured at all, correct?
Besides spit all over his face and falling to the ground, no.
You also said something to the effect of, at the time, I thought it was the person. Do you remember saying that? When we were talking about the identification, when you went to the precinct and identified the person who you thought did this to you and your husband, or at least to your husband, do you recall saying, I thought at the time it was the person? And so you were wrong at that time, correct? So you picked somebody out of the lineup, right? And the police didn't tell you anything else, you just picked a person?
I haven't spoken to anybody until yesterday.
Okay. Nothing further, Judge.
Any redirect?
It's one or two questions. I forgot to ask you the question I said I was going to ask you. So did the video that we watched accurately depict what happened in the parking lot? And second question is, and it's your memory though, that the car swerved slightly to the right to strike your husband. That's all.
No, thank you, ma'am. You may step down.
Ross, the Kroger lady?
May call your next witness.
Yes, Your Honor. Well, waiting, it's my understanding, talking to the defense counsel, he would stipulate to the admission of people's exhibit number 1 as accurate video for the purpose of the examination.
That's correct, Judge.
All right, exhibit 1 is admitted. Come forward to be sworn.
Wait, take C, raise your right hand. You solemnly swear to affirm the testimony about the truth, the whole truth, and nothing. See? States, go ahead and put the last name for the record.
My name is Rachel Roberts, first name Rachel, last name Roberts, ROBRTS.
You may inquire.
Now, Ms. Roberts, can you tell us how you were employed back in October of 2024?
I was an asset protection specialist for Kroger.
Okay, which Kroger?
All of them, actually. I worked in the whole division.
And is one of those that you worked for the one on Plymouth Road in Ann Arbor, Washita County?
Yes.
Now, at some point in time, did the police come to you and ask you to give them something about what happened on October 28th of 2024?
Yes, I was requested a full video.
Okay, and where were you when you asked that? At that store or some central
I was
location?
in the store.
At that store. Do you remember who asked you to do that?
It was Detective Ross.
Okay. And how did you pull the video of whatever he wanted?
It was using our Orchid Fusion camera system. It's for inside the store, and then I had to pull video off Flash to try to see if I can get the parking
Okay, and what happened when that happened, when you tried to do that?
So I was able to pull inside the store, but the camera for outside the door wasn't working at the time.
Okay, so you were able to pull a video from inside the store?
Yes.
And did you give that video to Detective Ross? Okay, that's all.
All right.
A couple follow-ups.
Yes.
You said that the camera system on the outside of the Kroger wasn't working at the time.
Yeah, the camera was under repair with technology. We had to put a service ticket in for it.
When you say under repair with technology, is technology a company or
Yes, it's within like the division's little group.
technology is that owned by Kroger?
Yes.
How long had that camera been down?
It was down for about 3 weeks because they did a full reset within the vestibule. So a lot of the cameras got knocked out.
What does that mean? I don't.
Basically they moved everything around. So like the shelving, that's when you walk into the main entrance, there's like a big shelving display, and then they had to move a bunch of tiles on the floors. So they had to use ladders to get to the ceilings as well to mess with the lights, and they knocked out some cameras.
Okay. Were there any cameras outside or in the parking lot?
Yes, there was a camera straight to the parking lot in the middle. There was a camera to the right, and then the camera that I needed was actually right outside the entry door. That's where the incident was.
Well, I'm a little confused. So, and it may just because I didn't understand your testimony, the cameras that got damaged while the things in the vestibule were being moved around.
Yeah, it was the first camera right when you walk in. It was right to the ceiling. So like, let's say I'm walking into that door, you look up, it was that camera that faced out. That one was damaged.
And that is the camera that would have captured the incident.
Yeah.
Okay. So there aren't any cameras like on the pole outside in the parking lot.
No.
I'm all set, Judge.
All right.
Thank you, ma'am.
Yeah.
All right.
Ready to go home then.
All right. You're all set. Thank you. You may shut down. Next witness.
Turns out, if you've been in a car accident
Thank you. Jonathan Kroger?
Yes. Come forward and be sworn.
Raise your right hand. You solemnly swear to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your very first and last name, record, please.
Detective Michael Ross, MICHAEL ROSS.
Are you man choir?
And how are you employed, sir?
I'm a detective with the Ann Arbor Police Department.
How long have you been a Ann Arbor detective?
6 years.
And at some point in time, were you, pardon me?
Detective for
2 years. At some time, were you asked to be in charge of the investigation of the incident that happened at the Kroger parking lot on Plymouth Road in Ann Arbor on October 28th of 2024?
Yes.
When did you get involved in that investigation?
I was assigned that case to investigate.
Was it that night, the next morning?
I believe it was the next day.
Okay, and you remained the officer in charge.
Correct.
Now, the video we were watching, you were in court while the video was played, were you not?
Yes.
Okay, where did you obtain that video?
Yes.
Where did you obtain that video from?
I obtained that video from Orange Theory Fitness, which was a fitness studio that pointed right where I said that.
Okay, is that in the same shopping area as the Kroger?
It
Is it, how close is it to the Kroger?
I believe it's maybe 1 or 2 businesses to the east of the front doors of Kroger.
But that's where you got that video?
Correct.
Okay. Now, as officer in charge, did you ask the complainant and his wife to come down to help identify who the suspect might be?
Yes.
Could you know when that happened how long after the incident?
I don't recall specifically, but I believe it was within a week.
Okay. And what was done as far as having them help identify the possible perpetrator?
I compiled a photo lineup. I had another detective administer the photo lineup to them as I sat in. Sure.
Okay. You had a suspect that was in the lineup?
Yes.
Is that why you did not conduct it yourself?
Correct.
Okay.
but you observed the lineup.
I did.
And did you observe Miss Yuling Lin observe the photo display?
Yes.
I hand you a smart as People's Post Exhibit number 2. And ask if you could tell me if this piece of paper is.
This is the photo lineup that I put together.
Okay. And is the defendant in that lineup?
Yes.
The defendant, are we talking about somebody in court today?
Yes.
Could you identify who we're talking about?
Yeah, he's sitting right there with the orange. Both of them.
Could may the record reflect he identified the defendant, Anthony Hamilton?
That objection, record shall so reflect.
Thank you, Anna. And what happened then when Ms. Lynn observed the photo lineup?
We showed, well, the other detective showed her each individual photograph and went through with her to see if anyone looked familiar to her as being suspect.
And what happened?
She selected Anthony Hamilton, said that he looked familiar and that she was 70% certain that it was him.
And is Anthony Hamilton the defendant?
Yes.
Okay. What photo was it? In the exhibit I've given you, what photo was in that exhibit?
That's mark number 4.
Okay, so she said he looks familiar and about 70% certain that's him.
Correct.
Okay. Now, at some point in time, did you also have a chance to investigate the 911 tapes involving this case?
Yes, but I did not listen to the call.
Okay, not originally, but have you since?
Yes.
Okay. And in the call, was the license plate of the vehicle given to the 911 operator?
Yeah, that's I think straight here, sir.
Excited utterance, Your Honor.
Well, he needs to lay a foundation for that then. You just can't assume a 911 call foundationally constitutes a excited utterance.
I think Ms. Lynn did do that. Husband was almost run over. She claimed that was just before the backing up incident. Was excited, was calling, got spit in the face and was calling the 911.
Well, herein lies the problem of why we don't have the actual complainant witness. I don't recall the complainant specifically saying that her husband made some excited utterances or laying that foundation. I know that what she described and said that her husband said, but she didn't explain how he said that and laid the proper foundation to get the.
Why is the license plate hearsay at this juncture, counsel?
For this witness, because he's watched the video, or I'm sorry, he listened to a call and he's relaying what was stated in that call.
But was it really for the truth of the matter asserted or for what was said and what they then did?
Well,
going to his state of mind as to for the truth of the matter.
Well, I would argue that it's for the truth of the matter asserted because brother counsel wants us to believe or wants you to know that what the license plate was and actually if it was given. And also the best evidence of that will be the 911 call itself.
Maybe. Well, when I'm not necessarily I don't know what I'd be accepting for the truth of the matter of what, if you're saying it's hearsay.
That the complainant gave the license plate and what that license plate is. I'm assuming that's what brother counsel is going with the question.
For the truth of the matter of what the license plate is. And your response to that, to the extent that it is hearsay.
But there was an excited utterance was given to 911 after a near death experience, after an almost accident and being spit in the face and confronting an individual.
Since I don't know the next questions, I will just indicate that I'm going to the extent that it is hearsay, that it's being offered for the truth of the matter that's asserted, which is what the number is, I guess, then I would
consider that at least based upon the testimony that I have at the time that the call was made, that it's a cited utterance, the individual is observing something as they're reporting it, which was the testimony of the first witness. However, I'm not sure that it is hearsay, so I'm also giving a provisional ruling that this evidence may be admitted for the purposes to show state of mind as to what the officers then did next. So.
You indicated that you did hear a license plate over the 911 call.
I believe so.
What did you do with the information about the proposed license plate number you heard?
At that time, nothing, because the vehicle had already been identified in the report. So the 911 call came after that.
Okay, did you ever learn what vehicle matched the license plate number that came over the 911 call? Whose license plate that was?
Yes.
Objection, that's now, I don't know to what extent he has done this investigation to find out what license and the car, the driver or the registered driver is associated with. I don't know where that information is coming from. I don't know if a partner told him that. I don't know what steps he took to find that information personally. It lacks foundation, and it sounds like hearsay.
Response.
If the information as to the license number is allowed in, then I think he's allowed to say what the investigation of that license number led to.
Well, just because you frame something as a part of an investigation doesn't make it per se admissible. And we're not talking about information he got from the 911 call. We're talking about information that he obtained some other way that hasn't been explained or made a foundation.
You get, sir, some to understand just me, you get a license plate number and then use some tool, I'll put it that way, available to you to identify that license plate number and what it's attached to, or the vehicle that it's attached to. Would that be correct in summary?
Yes.
Well, I'm gonna, I mean, quite frankly, in a matter of minutes, I can get a certified record if I know the number, and we can be done with this whole argument, because it seems rather silly to be arguing at this point in time. I'm going to overrule the objection. I'm going to allow him to testify as to what he did and what he discovered.
So what did you discover as to what car that license plate belonged to?
It belonged to Cynthia Harrison.
Harrison?
I'm sorry. Yes, I think it is Harrison.
Do you know her relationships to the defendant?
I believe it's her mother. It's his mother.
Okay.
Why you should never.
Now, at some time, did you go to Kroger to try to get a tape from Kroger?
I did.
Do you know how long after the incident that occurred?
I believe that was also the next day.
Next day. And you heard Ms. Roberts testify, she gave you a tape.
Right.
Do you have a copy of that here?
Yes, it is on the flash drive.
It's plugged in already? I wonder if we might. And did you have a chance to review the videotape that you were given?
Yes.
What did you see on the videotape?
I saw the suspect enter the store, which you could see his face a little bit better on the store video. Compare that to his SOS photo and determine that it was the same person.
So I wonder if I'll hit play and tell me if you could tell us if that shows what you said it shows. Okay. Okay, now we stopped the video. This is video which is marked as People's Proposed Exhibit number 3. And what do you see on the video now?
The suspect involved.
Now, how do you relate the person coming through the door as we see here on people's post exhibit number 3 with the incident?
Based on the other video.
What do you mean based on the other video?
So the Orange Theory video, where you can see the description of the individual that was involved in that video, the story of Kroger.
And how about time? Is there a time coordination between the first video and this proposed exhibit number 3? I mean, was that done at all, or is it just a closed description?
Yeah, it was a closed description, and I think the time, I don't think the time on the Kroger video was the accurate time of day. I don't recall, but the videos that lined up.
Okay. I want to hand you what's been marked as, by me, as proposed exhibit number 4. Ask you to tell me what that piece of-
Can I take a gander?
Oh, I'm sorry. Tell me what that proposed exhibit is.
It's a side-by-side of the Kroger video and the suspect's SOS photo.
By the Kroger video, I mean, the person, is that photo taken right off of the video?
It was a screenshot.
Okay. I move for the admission of both exhibits 2 and 4, Your Honor, and 3.
Any objection or what here to any of these?
One question. The photo, there's 2 photos on the exhibit that you have, correct?
Yes.
The one photo that is a portrait, is that the same portrait that was used in the photo array?
The one on the left? Yes.
Okay. Then I have no objection.
Exhibits 2, 3, and 4 are admitted.
I have no further questions, Your Honor.
Cross-examination.
I don't have any questions for this witness, sir.
All right, very good. You may step down. Thank you, sir.
I have no other witnesses, Your Honor. I move to bind over on the charge of great bodily harm and felonious assault.
Response.
So part of the reason why I asked, Your Honor, if you needed, or if it would be helpful to view a more zoomed in picture of this event was because I don't know to what extent a person can illegally try to hold a person in a spot, because what the proofs were did not rise to the level of a felony. And as your Honor knows, the only way that a citizen can make a citizen's arrest or keep somebody in a place they don't want to be is if they've committed a felony in their presence. There was no felony committed, at least before the purported use of the car or the misuse of the car. So you have a situation where even in the video, you can hear, for purposes of the exam, I'll say my client is yelling about, get away from my car. Why are you at my car? He is observed trying to leave. The complainant, and I don't think his wife, I think it was just the complainant, physically stops him from trying to leave a couple different times. And then that's when you see my client drive away. Now, if you zoom in closer, I don't think that this swerve that the first witness testified to is that purposeful. What you see is the car back straight out and then drive forward and straighten out as they're going toward the main road. There's no reason, if my client was trying to actually run this guy over, as it was characterized as, that he couldn't have just done it. If he was trying to turn the wheel, he just turned the wheel and he would have ran him over. Also, the lack of injury, as you know, for GBH cases, an injury is not required, but an injury can be used to show the defendant's intent to do the specific type of harm, specifically the great bodily portion. But on the flip side of that, if there's no injury and the witnesses testified that.
If a donation makes sense for you right now, I'm asking you to pitch in to the Democratic Party's
So you're arguing to me that with all what?
all these technical difficulties I'm having today, I'm going to go ahead and call the stream. But I will see you guys tomorrow.